Morning. It's always interesting. We can just see the numbers flicking up as we go along. So, good morning, everybody. Good to see so many of you joining in. Brilliant. Right, we will start our introductions then and get underway. So, good morning, everybody. I'm Ruth Mullen. I'm a partner and head of the public sector employment team here at Forbes. And I'm really pleased to introduce my colleague, Catherine Hare, who works as a professional support lawyer at Forbes, but supports our teams absolutely phenomenally and has been a resident expert and guru, keeping up to date with everything that's been going on with the Employment Rights Bill. It is a really big change to legislation for those of us who've been around a while and doing employment law for quite some time. So Kat's had a really big job on her hands, keeping up to date with everything and being able to bring you as much up to date information as possible. We do hope to run some more sessions into the new year as well as things are changing. So this morning I'm going to keep an eye on the questions. So if you do have questions, do pop them into the questions Q&A and I will intervene with Kat and we will ask some of your questions hot off the press. But without further ado, I am going to hand over to Kat to start the webinar. Thank you.
Thanks, Ruth. Yes, good morning, everybody. Yes, the Employment Rights Bill is taking up a lot of my time. I was reading the minutes from Hansard yesterday evening because it was back in the House of Lords yesterday, and I've got updates from that hot off the press. You'll be glad to know because the House of Lords are quite frankly creating havoc with the Employment Rights Bill, but we will get to that. So first of all, what is the Employment Rights Bill? So the Labour government describe it as the biggest upgrade to workers' rights in a generation. It contains a significant amount of changes to employment law and HR practices. We're going to have a busy few years, is all I can say. This was Angela Rayner who kind of was driving the Employment Rights Bill. When she stepped down as Deputy Prime Minister, there was some concern, especially from the unions, as to kind of what will happen to the Employment Rights Bill. Keir Starmer was very reassuring to the unions and confirmed that it's going to be carrying on as it is. So it is going through the parliamentary process. But with Angela Rayner stepping down, we do wonder if it will be watered down slightly when secondary legislation comes into force. But we'll touch upon that as we go along. But it is making its way through Parliament as we speak. So there are a significant number of changes. You can see here, we just thought it's useful to put it on a table to kind of see all of the changes that we're going to be looking at over the next few years. We are going to be going through these, so you don't need to make a note of them, but it's just interesting to see how many changes there are on the horizon, which are predominantly going to, enhance workers' rights, really. That's the aim of the ERB. So like I said, the bill is going through the parliamentary process, but it's having a bit of a torrid time. The Labour government had anticipated that the bill was going to receive royal assent, so you can see that final stage, and was going to receive it when Parliament came back from the summer recess, so early October time, but it hasn't. It's still kind of going through the parliamentary process, and the reason for that is because the House of Lords aren't happy with certain provisions within there. They criticised the Employment Rights Bill. They've described it as on the hoof. And I think that's because the Labour government promised in their manifesto that if they were elected, they would lay before Parliament within 100 days of them coming into office an Employment Rights Bill which would enhance workers' rights. Now, they did that. They did lay it before Parliament within 100 days of them coming into office, which is pretty good work. but there were some parts that were just weren't drafted correctly. They have had to make amendments as they go through. And some of the provisions within the Employment Rights Bill, the House of Lords have got an issue with, particularly with regards to the unfair dismissal rights, giving workers day one unfair dismissal rights. The House of Lords are not happy with that. So we will go through kind of what's going on, but the House of Lords are really pushing back on this, and it's unexpected because obviously Labour have such a big majority in the House of Commons. Usually the House of Lords wouldn't push back on things like this because they know that the House of Commons will then just veto any amendments. But they are pushing back, and we're in this period of, it's called ping pong, which sounds quite exciting, doesn't it? And in my world, it is. Because effectively, it's the Employment Rights Bill going between the two houses. So the House of Lords are making amendments. It's going back to the House of Commons. They're saying, no, thank you. It's going back to the House of Lords. And I did wonder last night if the House of Lords would kind of give up the ghost and say, okay, we're happy with as it is. You know, we appreciate the fact that we're not going to get any further with this. But no. From what I read last night, and I'm pretty sure that this is, I didn't manage to get to the end of the minutes because they were still being typed. But from what I gathered, that they're still pushing back. They certainly haven't acquiesced to the amendments that the House of Commons have made. So we're still in ping pong, which means that the bill still hasn't received royal assent. So that is delaying things slightly. And the reason why that's important is because when the Employment Rights Bill receives royal assent, not everything that you saw on that table is going to become law, because that would be absolute madness and chaos. So what happens is that the Employment Rights Bill will receive royal assent, and then there will be secondary legislation, so they're called regulations, which will bring in force other provisions. So these regulations will contain all the details, all the nitty-gritty that we need to kind of get our head around as to what these new rights are going to be. And what the Labour government have produced helpfully is this roadmap. So what they've said is that when the bill receives royal assent, there are going to be a few things that come into force straight away. You can see there on the bottom of the slide, it's mostly to do with trade unions, some kind of quite niche points with trade unions. They are going to repeal the Strikes Minimum Service Levels Act, which that was the provision whereby if there was going to be a strike in the public sector, there was going to have to be certain people working. That's going to go. I'm not sure it was actually used. Especially for education, it hadn't been used. So that's going to go. But there's a few minor things that are going to change when the bill receives royal assent. But in this roadmap, you'll see that they've kind of set out what's going to happen when. Now, the longer it takes to receive royal assent, I think these timescales are going to slip. So it might create a bit more uncertainty, because we were quite grateful when this roadmap was produced, because we kind of then know how to prepare and when to prepare for things. But this was on the basis that royal assent was going to be when they came back from the summer recess. Obviously, we're kind of mid-November now, so it has been delayed slightly. So we're not sure what's going to happen with this roadmap, but it gives an indication of roughly when we can expect things to happen. So you can see that there's going to be consultations launched. There have already been consultations launched, which we've responded to as Forbes solicitors, and we've made sure that the government have realised that perhaps sometimes there are some unintended consequences that can be that can arise from certain provisions that they propose. And the consultations are a really good thing, because they are taking views from the trade unions, from organisations such as yourself, from commercial organisations, and trying to get this middle ground, I suppose, where the workers get the rights that was part of the manifesto, but also they don't hamper growth within organisations, within businesses, and they still make it easier for a business to be able to function, rather than have too many rights for workers, which may prohibit that. So if you look at April 2026, you can see this is when most of the meaty changes are going to be start coming into force. So you can see there the day one rights to paternity leave and unpaid parental leave are going to be in April 2026. SSP is going to be from day one in 2026 to April 2026. But what is useful is that for those of you who've been around as long as Ruth and I have, previously employment law changes did tend to be in April and October. We are going back to that, which is useful because with the previous Conservative government, there were lots of piecemeal reforms that kept kind of appearing and were happening in June, July, May, and it was really hard to keep track of it all. So the Labour government are focusing on changes being mostly April and October. So you can see April 2026 is kind of when some of the more meatier changes are going to be coming into force, we think. There's also going to be equality action plans that are going to be asked for on a voluntary basis with regards to gender pay gap and menopause. Whilst these are going to be asked for on a voluntary basis in April 2026, further down the line, these are going to become compulsory. So first key takeaway, I think with the menopause, that has been a focus of the Labour government, encouraging workplaces to protect employees, to help employees who are going through the menopause. So I think it's thinking about, do you have a menopause action plan in place? Do you have menopause champions? Do you have policies which says, look, we support all employees, in particular those that's going through the menopause. This is how we support those individuals. So I think about the menopause, think about putting that in place now, because that is something that the government are going to be focusing on and will be asking for evidence of what organisations are doing to assist in that regard. You'll see then in October, we have some more quite meaty provisions that are going to be coming into play. There's going to be a ban on fire and rehire. There's going to be a requirement for employers to take all reasonable steps to prevent sexual harassment, which is a really high bar, which we'll look at. And also a requirement for employers to prevent third-party harassment of employees, which I think is going to be huge. You remember that was a protection that was in place. It was abolished. It's going to be coming back. And there's also, you'll see there, the extension of the tribunal time limits to 6 months. So there's going to be an extension of the time limits to lodge a claim at the employment tribunal from 3 months to 6 months. So giving people more time to lodge claims. And then 2027 is also going to be a big year. And that's when there's going to be the day one right to protection from unfair dismissal. That's going to be coming into force then. There's going to be changes to the flexible working request system, but not massive changes that we thought there might be. And then you can see there's going to be the requirement for the action plans to be put into place with regards to gender equality and the menopause too. So that just gives you a flavour of what we have in store. Like I said, there have already been consultations launched and their outcomes have been delivered. There's currently 4 consultations which are live with regards to trade unions and also the enhanced protections for family rights as well. I have responded to those consultations on behalf of our clients to kind of highlight, I suppose, what we think may be the issues that perhaps the government haven't thought of. So we'll continue to do that. But, it's worth having a look. They're going to be live until mid-December, so you can have a look at those. And of course, feel free to contact me if you have anything that you want to add in yourself, because I can certainly do that on your behalf. So I think the big ticket item in the Employment Rights Bill that has been getting a lot of press is the right for individuals to be able to claim unfair dismissal from day one of employment. Now, the length of service that's needed to bring a claim for unfair dismissal currently is 2 years. And it has changed. So it previously was 6 months. It has been a year. Now it's 2 years. So it's something that other previous governments have tinkered with, but this was very much part of Labour's manifesto. They were very keen that all employees should have unfair dismissal rights from day one. Now I've put a question mark there, you'll see, because the House of Lords are not happy with this. They think it will stifle business growth. It will stop people from hiring employees. Perhaps those people that perhaps they were think that organisations might be thinking, oh, I'm not too sure. I'll give them a go. Um, it will stop that. So they are concerned about that. Um, the the government have listened to the concerns about day one unfair dismissal rights. And what they've done is that you'll see there in the second paragraph in that they've said, okay, still want individuals to have these day one unfair dismissal rights. But what we'll have is this initial period of employment where if you do hire somebody, for example, who isn't working out, then you can follow a lighter touch process to exit that person from the organisation. Now, effectively, this initial period of employment is a bit like a probation period. We think that the government are planning for this to be a period of maximum of 9 months. But this initial period can be used for capability dismissals, conduct, illegality, and some other substantial reason relating to an employee. This initial period of employment wouldn't apply to redundancy, though. So that's something to be aware of. Redundancy is excluded from that initial period. So the way it would work is that you would have this initial period where you may be able to follow a lighter touch process. We don't know what that is. The House of Lords last night said, why don't we just not have all of this complication? Why don't we just say that people should have 6 months service before they can bring a claim for unfair dismissal? So 2 years is too long. 6 months seems sensible. That's a halfway house. The Labour government keep pushing back and saying absolutely not. So that's where we are at the moment. Everyone seems to be digging their heels in. I think whatever happens, the 2 years qualifying service to bring a claim for unfair dismissal is going to go. But we need to see what's going to happen with regards to the House of Lords and the House of Commons. It's interesting. But I think what we need to be aware of is that people are going to get more rights. So it's important that you're aware of that when you're thinking about your recruitment, when you're thinking about managing people and thinking about your probation periods. So, it's going to be 2027. We've got old Leo there, 2027 problem. We know there's going to be consultation on this, especially with this initial period of employment. If the government succeed with what they plan to do, they're going to ask us, what should this initial period of employment look like? But this change is on the horizon, but not for a while yet. But I think Ruth and I would always say you need to get ahead of the game with things like this. So you need to think about, have you got your probation periods in place? Do you make sure that you monitor people during your probation periods? Are your line managers trained well enough to know when somebody perhaps isn't performing in the probation period and can flag it? Because if this initial period of employment comes into play, then probation periods are going to be absolutely key if it's a case of they're not the right fit. And I think you really need to think about your recruitment processes to make sure you get the right person from the outset, so you're not having to deal with this initial period of employment or whatever it looks like. Because if it is the House of Lords, if the House of Lords provision does become law and they're going to have unfair dismissal rights from 6 months, then we're still going to have to be, probation periods are going to be absolutely key. So I think another key takeaway is think about your recruitment processes for getting the right people into the organisation, but make sure that your probation processes are watertight, and that also, that it's in your contracts, etc. The changes to unfair dismissal rights are going to give 9 million additional employees the rights to bring claims. That's from the day one. The employment tribunal system is already creaking. One of our colleagues, Laura, she was at the employment tribunal this week. Laura McHugh, one of the partners, she was doing a pre-hearing review, and the employment judge told her that they are currently listing hearings for the end of 2027. So that's Manchester Employment Tribunal. So it's already creaking the employment tribunal system. So that's this is going to add much more pressure to it.
Kat, I was just going to add as well on that with the extra claims and the extra time that's going to be allowed for claims to be pursued, those things are going to be really tricky to manage in practice. And we are seeing some tribunals where they have got, limited days available are trying to shoehorn cases in. For example, on the 7th and 8th of January, when we've only just had the case accepted by the tribunal, giving us very little time to prepare, which, that's not appropriate for clients as well, because it can be really difficult and you do need proper time to prepare. So it's a real balance at the moment. And I think employers have got to be really mindful about these things and, like, as you say, managing things in the interim.
Yeah, certainly, because that's just this is just the first change. And along with that, um, the Employment Rights Bill is going to extend the time limits for lodging a claim at the Employment Tribunal from 3 months to 6 months for discrimination and unfair dismissal claims. The Employment Rights Bill, the way it's drafted, seems to exclude breach of contract claims, but we don't know if that's intentional or not. So we're not quite sure what's happening with that. And what I would say as well, in that this wasn't included in the Employment Rights Bill initially, this has been added as an amendment. Quite frankly, I think they forgot to add this in, because I was going through saying, where is this? Because it was a clear manifesto promise, but it's now been added. So what this means is that it's going to give individuals much more time to be able to go and get legal advice, to think about lodging a claim, to get the funding in place. I think 3 months is quite a short time scale. The government were concerned that it didn't give people enough time to access justice. So that's why it's been changed. It's going to be in force in October 2026. But the government reckon there's going to be an increase in employment tribunal claims by 15% because of this change. I think that's far too conservative. I think there's going to be much, much more. There was talk about employment tribunal fees being reintroduced. You remember that they were introduced previously, and they did try again to introduce them, but it was challenged by the unions, and fees have been abolished. So it's free to lodge a claim at the employment tribunal. Minimal fees were thought going to be brought back in and to try and help fund all these additional claims, but the Labour government have confirmed categorically that fees will not be reintroduced in the employment tribunal. So it's going to be free to lodge a claim at the ET as it is at the moment. So along with the increase in the time limit for lodging a claim, you may have seen that the period for ACAS early conciliation is also going to be extended from the 1st of December this year. So this kind of, I suppose, came out the blue. Some regulations were laid before Parliament, and we all kind of thought, well, where's this come from? And when I read the explanatory memorandum as to why this has changed, the reason why the period has increased from 6 to 12 months is to relieve the pressure on ACAS. And we found that, Ruth, haven't we, that ACAS are stretched. Sometimes we just don't hear with regards to early conciliation. Because an individual has to go through early conciliation before they lodge a claim at the employment tribunal. Obviously, there's a significant amount of claims being lodged at the tribunal. ACAS just aren't able to deal at the moment with all of the people going through early conciliation. And sometimes
it's also the case as well at the moment that it's not just the early conciliation, it's the conciliation during cases. So we spoke with ACAS last week because we had a case that is listed for something like May next year, and they hadn't yet appointed a conciliator to deal with it, which meant that there could be no real discussions between the parties. And what we've learned is that if you are wanting to have conversations around settlement, they will try to sort of accelerate the progress. But that means that effectively the cases are stuck, and that's very difficult when you're dealing with a litigant in person, someone that's pursuing their own claim, and they don't really understand what they need to do. it can kind of stagnate any opportunities for settlement or encouraging withdrawal of claims. So,
Mm.
from an employer's point of view, really tricky at the moment.
It is. So I can see why they've increased the early conciliation period. But I mean, what this means is that if it's going to be 12 weeks with regards to conciliation, if the time limit for lodging a claim is extended to 6 months, from an organisation point of view, you may not know a claim's been lodged for potentially, a good year by the time you hear from the tribunal. So it's going to add to more uncertainty. And there's also be concerned as well from groups representing employees saying that access to justice is going to be delayed because they're not going to be able to get in front of the employment tribunal for years. So we'll have to see how this works. But yeah, just something else for you to have to deal with. Um, SSP. So for those who pay SSP only, it's only paid from day 4 of sickness. We have these waiting days. Labour government weren't happy with that because they said it deterred people who were, genuinely ill from getting payments, and they were coming in. There was presenteeism where people were coming in when they were poorly. So they've changed that. So SSP is going to be payable from day 1 of sickness, and it's also going to be eligible to given to everybody. So those previously who weren't below the lower earnings limit didn't receive it. Now those people are going to receive it, but on a proportionate basis. So this is going to be April 2026 when the changes to SSP kick in. There are going to be changes to the trade union provisions. We expected it. This was very much Angela Rayner's baby, the Employment Rights Bill, because she wanted to make sure that the trade unions were strengthened, and they've certainly done that within the Employment Rights Bill. There's going to be more obligations on employers, particularly with regards to this duty to notify a worker of their right to join a trade union. So you all give individuals their contract of employment on day 1, the written particulars. The idea is that alongside those written particulars that you need to give individuals, you also tell them you've got the right to join a union if you'd like, and this is how you go about it. So it's an obligation on an employer to give this information. Now, it's quite onerous, and there is consultation out at the moment, which I've responded to, because the government is saying, look, how should this duty to notify work? Should it be a direct duty on an employer to give each individual effectively a letter to say, do you want to join a union? Do you want to join a union? Or should it be indirect? Should there be an intranet where people can see how to join a union if they want to? Or can you pop something on a notice board? I think the indirect method will probably be better for organisations because it's one less thing to remember. But then also the provisions in the Employment Right Bill kind of talk about having to frequently remind individuals they can join a union. So what does that frequency look like? Should it be annual? Should it be 6 months? I think it's too onerous to be asking employers to remind people that they can join a union every 6 months. But we'll have to wait and see. But that's something just to bear in mind. These trade union provisions aren't going to be coming into force straight away because there is consultations on this. I think it's going to be October 26 when we're looking at this. But just something to be aware of, this obligation to notify. This is quite a wordy slide, and we are going to share the slides. But I think it's just I think what the key thing to take away is that it's going to be easier for trade unions to obtain recognition, and I think it's going to be easier for unions to be able to take strike action or threaten to take strike action. There's going to be consultation on what this looks like. The House of Lords aren't particularly happy with this because they feel like it may hamper an organisation being able to kind of change the ways they work, change the terms and conditions to be dynamic. The government are saying, no, we need to protect workers. So it's really difficult. It's that balancing act. But I think the key takeaway is there are going to be changes. It's going to be easier for unions to get recognition. And I think we're already seeing that where the unions are kind of gearing up to be knocking on the door to say we want recognition, from SMEs all the way through to large organisations. So yeah, just bear that in mind. I know Ruth's dealing with an issue at the moment, aren't you, Ruth, with regards to unions and threatened strike action, and it's
Yeah.
something we're going to be seeing more frequently, I think.
Yeah, and it is going to be a kind of watch this space
Yeah.
for those people that are on the kind of brink of strike action, or if ballots going on at the moment, because we'll have to see when the thresholds and things on the ballots change and when the ballot notices change, because at the moment they're the main areas where employers can challenge. So again, it is one for us to keep a watching brief on, and you'll see now why Kat's been kept very, very busy keeping a watching brief on all of this stuff to help us.
Yes, so yeah, easier to get recognised, easier to threaten industrial action. There's also going to be a right of access as well. So there's going to be these access requests that a union can make to say, look, we'd like to have access to your organisation. Thank you very much. And it can be for various purposes, which haven't been defined as yet. But it is clear that it can't be for the purpose of organising industrial action. So that's useful at least. But if you when you get these access requests, you then got to respond to the access request. If you don't respond to it or you decline it, it will then go to the Central Arbitration Committee, who will then mediate on this. So again, it's something else to be aware of. But I mean, from a practical point of view, you're wondering if you're a school, for example, how is this going to work from a safeguarding point of view? Because you can't have people just accessing your premises and willy-nilly. We need to think about that practically. And also, you do wonder, how have the unions got enough officials who are going to be able to kind of, be going into organisations to access them? To be taking all of this action, you do wonder if the unions are properly resourced as well. But just something else to be aware of. This is part of the consultation too, which I have responded to and raised those points, especially about from a safeguarding point of view of how on earth will that work in practice.
Also, Kat, it'll be interesting to
Mhm.
see how it sits with facilities time, because at the moment,
Yes.
trade unions have already got certain rights to, spend time with their members and to have time available to consult and those sorts of things. So it'll be
Yeah.
interesting to see how this sits alongside of that. And I
Mm.
think it's probably likely that where sort of trade unions will probably push on this will be the areas where employers perhaps aren't currently giving them or don't
Yeah.
have a facilities agreement with them, a facility time agreement with them specifically, or if there is no collective negotiating
Mhm.
position. I think it may be the case that those trade unions will perhaps use that to try and get that access. I think that's probably
Yeah,
where it'll
I
come.
agree. I agree. So yeah, again, watch this space on this at the moment. So, moving on to the duty to take all reasonable steps to prevent sexual harassment. So, hopefully, you're all aware and you've attended the sessions that Ruth and I have delivered about the duty that's been placed on employers to prevent sexual harassment in the workplace. So, this is a proactive duty on employers to prevent sexual harassment in the workplace. Now, when this bill was going through the parliamentary process, it originally said employers need to take all reasonable steps to prevent sexual harassment, and employers need to take those all reasonable steps in relation to third party harassment too. Now, the House of Lords said that's absolutely ridiculous. How can an employer take all reasonable steps? So they put a big red pen through the word all. And they also said, we're not having it for third party harassment too. How's that going to work in practice? We've tried it before, it's not worked. And they put a big red line through third party harassment too. So the bill came into force in October 2024, saying that employers had to take reasonable steps to prevent sexual harassment. It's still tricky for organisations to think about what those reasonable steps look like. Ruth and I do a cracking session on training employees to kind of know what sexual harassment looks like, how to report it, employers as well to make sure they've got those reasonable steps in place. But that seems sensible. The Employment Rights Bill has put the word all back in. So employers are now going to have to take all reasonable steps to prevent sexual harassment in the workplace. What that means is that if an employment tribunal thinks of something that perhaps didn't even cross your mind, they could say, well, you didn't take all reasonable steps because we think this is a reasonable step. So on that basis, you've not taken all reasonable steps. And therefore, if somebody has been sexually harassed in your workplace, we're going to increase the compensation that individual's got because that individual wasn't protected. So it's going to be a high bar. We're going to have to see what it looks like. We haven't seen any cases yet with regards to claims brought for sexual harassment since the Act, the Worker Protection Act, came in. Probably because there's so much of a backlog in the tribunal, we're not going to see it for another couple of years, I think. But be aware of that. Also, be aware that third-party harassment is back. So it was originally in the Equality Act. It was then repealed in October 2013 from the Equality Act because it didn't work. It just didn't seem to work in a business setting, in an organisation setting. It wasn't drafted particularly well. And I think the general consensus was it was too difficult for employers to have to police it and deal with it. It's going to be back. It's coming back. It's in the Employment Rights Bill. It's going to be coming into force in October 2026. And I think what you need to think about now, so another key takeaway is think about where your staff, where your employees may be in contact with third parties. So parents' evening, customer facing roles, contractors coming onto site, because you need to think about preparing now those risk assessments, thinking about if you do have contractors that are coming onto site, thinking about your commercial T's and C's, put in there, we do not tolerate any kind of harassment in our organisation. It's a zero tolerance. If you're found to be harassing our individuals, action will be taken. Just things that start putting them in place now, because this third party harassment is going to be quite onerous, I think, and it's really important to start thinking about putting in place those measures now and those assessments as to where the risk may be.
We've had a question actually on that.
Okay. Yes,
of whether a pupil would be classed as a third party. I think I know where the person that's asked the question is coming from, and I think it is going to be difficult because I think a pupil could be a third party, and I think unless that's specifically excluded, which from what I've seen isn't. That could be quite difficult as well, depending on your types of school and your pupils as well, because it's what knowledge they have, and if you've got sort of send provision, or that sort of support is required, that's going to be very hard because it is going to be very difficult to stop and prevent pupils in particular from doing though having those behaviors and learning those ways, I think.
Yeah, I think so. There are going to be regulations that are going to appear at some point, which are going to specify what reasonable steps look like. And we're hoping that kind of query, and there's going to be we're hoping there's going to be sector specific provisions to identify what would be expected in each sector. So so I would hope that these regulations would help us with this. And that's
it's going to be difficult. I think it's going to be
Mm.
difficult, isn't it? And we've had another question on the back of that, which is that the organisation is one that has pupils with SEND who can't self-regulate and might say a comment to a member of staff. So I think it's going to come down to making sure those assessments have been carried out and the steps have been taken to try and prevent it, but also perhaps where it can't potentially be prevented, how that's managed with the members of staff. And I know from that organisation, I know it won't mind me saying, over COVID, it was very difficult because where the guidance was in place for keeping people, apart by 2 meters, that wasn't possible in that setting. So it's going to be, it is all reasonable steps. So, to suggest, for example, a SEND pupil can never say a comment to a member of staff, I don't think could be considered a reasonable step. But I think having undertaken the risk assessments, having put supporting for members of staff where those things happen, and a mechanism for reporting and addressing those issues, I think will have to be considered by
Mm.
tribunals to be reasonable steps.
Yeah, I think it's just about documenting and making sure that you've thought about it and you've put steps in place as far as you can. But I think the paper trail is going to be absolutely key. So, like this is what we think is going to be in the regulations, that you've got to carry out assessments, so risk assessments effectively, and then show kind of how you then mitigate those risks. Making sure you've got your policies up to date, that people know where the policies are. Know that if somebody then feels like they have been harassed, sexually harassed, or harassed by a third party, they know exactly who to go to, and make sure that if it's your line managers, the line managers know how to deal with it. And yeah, and I think it's just important that you have that paper trail in place, and it's important to do that now, because obviously there is that duty to prevent sexual harassment, to take the reasonable steps that's already in place. So yeah, think about training, risk assessments, getting your ducks in a row. So another key takeaway, I think, is just to think about that now. But these regulations, we are hoping, are going to specify kind of what a tribunal is going to be looking at. But in the situation we've discussed, there's only so much you can do, isn't there? So it has to be sector specific, and it has to be there's an element of reasonableness there. But I think it's going to be those organisations that don't do anything that are going to be really criticised. And of course, remember that there's employment tribunal action, but there's also the Equality and Human Rights Commission as well, who can take their own enforcement action. You may have seen McDonald's recently, they keep taking enforcement action against McDonald's because there's so much sexual harassment that seems to be recurring that they have to keep going back in. So, yeah, just be mindful of that, but certainly, yeah, start getting your ducks in a row now. Now, 0 hours contracts, exploitative 0 hours contracts specifically, that's something that the government have been very, very keen to deal with as part of the Employment Rights Bill, and it stemmed from P&O Ferries. Do you remember when P&O effectively dismissed all of the staff and then said, we'll re-engage you, but on far worse terms and conditions? So that's been a real issue for the government, for Labour, and from the trade unions particularly. So they want to ban exploitative 0 hours contracts, which I think is quite right. However, you do wonder with 0 hours contracts. I mean, I've never come across an employer who has used exploitative 0 hours contracts. I think 0 hours contracts tend to work well for both, organisations and individuals, because it works well from a childcare caring point of view. There's flexibility there. However, the Employment Rights Bill, as it's drafted, introduces an obligation on employers to offer a guaranteed hours contract that reflects the hours qualifying workers and qualifying agency workers regularly work over a reference period, which we think might be 12 weeks, but we're not sure. Now, the House of Lords have questioned this and just said, well, why do you need to do this? Does this actually work? What the House of Lords have said is they've proposed an amendment to say, why don't you say to 0 hours workers and agency workers, if you want to opt in, so opt in to having this guaranteed hours, then that's great, but you don't have to have them. There doesn't have to be this obligation on employers to ask individuals, after you've worked 12 weeks, do you want guaranteed hours or not? This obligation to give the guaranteed hours. Obviously, a 0 hours worker could say, I don't want them, thanks, but it's something else for employers to have to be thinking about. It will apply to guaranteed hours contracts, but also minimum hours contracts. So you can't just say, well, we'll employ you for an hour a week to try and get around the 0 hours point. And then there's also going to be a provision whereby if a shift is changed at short notice or curtailed, then the individual would get compensation. We don't know what this notice is going to be. Again, it could be 7 days, it could be 48 hours, we're not sure. But this is something the House of Lords are really, really pushing back on. So again, we're going to have to see what happens with this, whether it's going to be an obligation on employers to have to offer these guaranteed hours, or whether it's going to be the other way around, where employees kind of put their hand up and say, look, I have worked with you for this reference period, please can I have some guaranteed hours? So we're going to have to wait and see. But again, key takeaway is that you need to think about your staff. So if you have people on 0 hours contracts, but in reality, they work 30 hours a week for you every week, they're not 0 hours. So you might as well think about, changing their contract to reflect what they're doing, because what you don't want is people to be inadvertently caught by this, and you have to offer them these guaranteed hours when in reality they're not a 0 hours worker. And I think sometimes it's just easy, isn't it, just to kind of have for people just to continue as they are. But I think doing an audit now would be absolutely key. What kind of workers do you have? Do you have people on 0 hours contracts? Do they need to be on 0 hours contracts? Um, do you use agency staff? Do you use supply teachers? Do you need to do that, or is it better for you to have a teacher that kind of floats to do that supply work? So it's important to think about now doing the audit as to kind of what you have in place and try and get your ducks in a row before these provisions come into force. But we have got a bit of time with the 0 hours contract point.
Kat, I think when we
Of
signed up
course.
to the session, somebody did put a question forward about what to do with their contracts and if they've got sort of variable hours contracts, what to do. So I think at the
Okay.
moment the answer is all of the things you talked about in terms of the audit trail,
Yeah.
and just seeing where you are with them and kind of waiting and seeing until we know what
Yeah.
what is going to come from the consultations. But I
Yeah.
think something you and I talked about is if somebody's not really doing the 0 hours contract and they're regularly doing hours, then maybe they're not on the right contract. So the audit is probably going to reveal that. And it's probably helpful to say we are planning on doing an extra session on this as things develop and trying to keep everybody in the loop with what's going on. So hopefully we'll be able to keep you up to date as well.
Yeah, of course.
Thank you.
Yeah, thank you. And then alongside this as well, the House of Lords have got a real bee in the bonnet about seasonal work. Put the Santa hat on there because my daughter thinks it's Christmas every day. Every day she wakes up and asks, "Is it Christmas?" No, we've got quite a long time to go yet. But seasonal work, because how will that work from this offer of the guaranteed hours contracts? Because if you have somebody who works for a set period, for example, over Christmas, a busy period, you don't want to be having to offer them hours in January when there's no work to do. Um, so the House of Lords has said, look, you need to define seasonal work and we need to carve that out because that's not going to work with this offering of guaranteed hours. Um, Now, what the House of Commons have said and the Labour government have said, we don't need that because instead of having seasonal workers, why don't you think about annualized hours contracts? Or why don't you think about limited time contracts, which are going to fall below this reference period? So that may be a way around it. That's kind of, I suppose, what the Labour government are kind of seeing maybe as a workaround, these annualized hours contracts. But do you want people on annualized hours contracts who you would only ever have to work at busy periods? So we're going to have to wait and see. But the House of Lords are, again, last night I was reading that they are pushing back on the seasonal work definition. So we'll have to wait and see what happens with that. But I think that might be quite useful actually. So wait and see. Flexible working, I will just canter over this because we thought there's going to be massive changes to flexible working. We thought everyone was going to be able to work 4 days a week for full pay, and that every request had to be approved. That's not the case. Not much is changing. It's already a day one right. The 8 reasons for rejecting a flexible working request are going to remain. The only difference is you're going to have to show that you've been reasonable if you're refusing a request, which I think all of you would be anyway. So in case of you can't just say computer says no. If someone's put a flexible working request, you would need to kind of consult with them. You need to say why that couldn't be accommodated and just kind of demonstrate that you have been reasonable. So document all of that. Paper trail will be key. It's not going to be until 2027, which seems like a very long lead time for quite a minor change. But I think it's just really important just to think about being reasonable. You can't just say it won't work for us. You need to show why and which of the 8 reasons for rejection that you're going to rely upon and why you're relying upon that. Now, the Fair Work Agency, again, this is one of Angela Rayner's babies. She described this organisation as really having teeth, which is quite terrifying, isn't it? But effectively, what this organisation is going to do is that at the moment we've got people kind of working in their own silos. We've got HMRC, we've got the Employment Agency Standards Inspectorate, and we've got the Gang Masters and Labour Abuse Authority. This Fair Work Agency is going to cover all of that, going to bring it all into one agency who are going to have these powers to enforce relevant labour market legislation. So they're going to make sure SSP is being paid. They're going to make sure national minimum wage is being paid. They're going to make sure people are able to take their annual leave and that you can demonstrate they've taken their annual leave and they've been paid for their annual leave too. They're going to have the right to knock on a door and say, show us all the documents that you've got, please. They're going to be able to speak to individuals to kind of find out what's going on in an organisation. And what's very interesting is they're going to be able to bring employment tribunal claims on behalf of individuals who may not want to bring a claim. So they're going to be able to take action. I don't know how that's going to work in practice. We're going to have to wait and see. But yeah, this organisation are going to have teeth. From what we hear, it is going to be properly resourced. But I think it's going to go after those unscrupulous employers who perhaps aren't paying holiday pay, paying below national minimum wage, paying cash in hand, etc. But another key takeaway, make sure that you've got all your documentation in place, because if you have a knock on the door from the Fair Work Agency, you want to be able to demonstrate, yes, everybody's taken their annual leave this year, or we've asked everyone to take their annual leave and everyone's been told if you don't use it, you lose it, because here's the email, here's our documents, here's our spreadsheet. Yes, they've been paid, here's the pay slips that show it. What you don't want to do is scrabbling around to just kind of say, oh, we think we've done X, Y, and Z, but we can't document it. So get your ducks in a row with that. And it's Matthew Taylor who's going to be heading up the Fair Work Agency. And for those of you who've been around as long as Ruth and I have, you'll remember the Taylor Review, where he tried to tackle employment status. It was a very valiant effort. Didn't really go very far, but he did try, and I think he'll be quite good at this. We did think it was going to be a trade union official who was going to be running the Fair Work Agency, which I think it probably would have taken on a different dynamic. But yeah, I think Matthew Taylor's quite a good appointment. But I think, yeah, key takeaway, this Fair Work Agency, they are going to have significant powers. They are going to be asking for documentation. So it's really important that you have that ready to go if and when you're asked for it. It's going to be more protection with regards to family leave. So paternity leave is going to be a day one right. Unpaid parental leave is going to be a day one right. And bereavement leave is going to be extended. At the moment, there's parental bereavement leave. It's going to be extended with regards to a general bereavement leave. There's currently a consultation about this at the moment to kind of see how this looks like, how far it should be extended, who should be able to take bereavement leave. Should it be extended family? Should it be step families? It's going to be quite difficult, I think, to legislate on. But yeah, be aware that there's going to be those changes that are coming into place with regards to protection for family leave. And there's going to be enhanced protection for pregnancy and new mothers, and also those returning from a period of statutory family leave. The enhanced protection against dismissal is something which I think is going to be quite difficult again to legislate, because what you don't want is a blanket to say that anyone who's taken any period of family leave or they've been on maternity leave, they can't be dismissed for a period of 6 months. Because if somebody commits gross misconduct, you can't just have them just sat there with their feet on the desk saying, well, you can't touch me. Good luck, everybody. That's not going to work. So whilst it's a good concept that those perhaps coming back from a period of family leave need a bit of time to kind of get up to speed. I think that's great. But we need to think about how that's going to look in practice, because what if somebody is just not performing? You can't be expected to have them in the organisation for the period just because they've been on family leave. So we're going to have to see how this works. This again is open to consultation. So I have responded on this to kind of say, look, we need to think about the carve-outs here. So we'll see how that goes. But I think a blanket protection against dismissal, we're not going to see that. There are going to be some carve-outs. And then collective redundancy consultation. There are changes to this. There were wholesale changes where effectively it was turned on its head when it was initially drafted, the Employment Rights Bill, with regard to collective redundancy consultation. That hasn't happened. They've re-amended the Employment Rights Bill, so that the changes aren't going to be as impactful as we thought they were going to be. So obviously, there's a duty to collectively consult for employers proposing 20 or more redundancies at one establishment within a period of 90 days. So you have to collectively consult. If you don't do it, there can be a protective award of up to 90 days pay. Now, the Employment Rights Bill is going to increase that protective award to 180 days pay. So that's quite punchy if you don't do collective consultation. There's also going to be what's called a threshold test, where if there's 20 or more redundancies at one establishment, collective consultation kicks in. But this threshold test may say it's a proportion of the workforce. We don't know what the threshold test is. We're going to have to wait and see with that. But the changes that were proposed aren't going to be as significant as we previously thought. So this is quite helpful. But we'll have to see what this threshold test is. And obviously, the increase in the protective award is quite punchy if it's a case of you've not collectively consulted because you didn't realise you had to. 180 days pay is quite significant. Fire and rehire as well. The Labour government have been very keen on banning fire and rehire. At the moment, there is a statutory code of practice in place for fire and rehire that if an organisation wants to dismiss and then re-engage on new terms and conditions, it's kind of a last chance saloon kind of scenario. It's not great from a reputational point of view for fire and rehire, but some organisations need to do that to preserve, the business as a going concern. But Labour effectively is saying that we're going to ban fire and rehire. So we're going to ban the practice of organisations dismissing their employees and re-engaging on new terms and conditions. There is one exception. If an organisation is in financial difficulties, it may be possible to fire and rehire. The financial difficulties mean in the public sector that they can't carry out their function, their statutory function. And in the private sector, it's the employer's ability to carry on the business as a going concern. Financial difficulties test. I mean, I wouldn't want to be the test case to see if we're going to meet that test or not. But yeah, just be aware, fire and rehire is going to be much more difficult to go through a fire and rehire process. Conscious of time, but just quickly on the last couple of slides. With non-disclosure agreements, this has been a last-minute amendment to the Employment Rights Bill, but it's going to contain provisions which are going to restrict an employer's ability to enforce a non-disclosure agreement where it relates to disclosures with regards to harassment and discrimination. So the restriction's going to be in relation to an agreement between an employer and a worker, such as an employment contract or a settlement agreement. So that's something we're going to have to look at carefully when we're drafting settlement agreements to make sure that we're not inadvertently falling foul of this provision. It's not enforced as yet. We're going to have to consult on this, but we're going to be very mindful of that if there is some kind of settlement agreement, because it may be that the NDA provisions are captured in a settlement agreement if a settlement agreement is with regards to harassment or discrimination. So we'll be mindful of that and keep you appraised of developments. And public sector outsourcing, the Procurement Act is going to be amended because the government want to avoid this two-tier workforce. And what they're saying is that for any public service which is outsourced, the contractor's direct hires must be treated not treated less favourably than the incoming public sector workers. So this will avoid a two-tier workforce because everyone's going to be on the same terms and conditions. But that means for commercial organisations that are taking on public sector contracts, their direct hires are going to have their terms and conditions significantly enhanced if they're going to reflect those that the public sector workforce have. So we're going to have to see how that works, because I think many commercial organisations have seen this and said, well, we would never take on a public sector contract then, which would defeat the purpose of it. So there may be some carve-outs for this. The Local Government Association have said, there needs to be thought behind this to see how that's going to work in practice. We're going to have to wait and see. but I think it's one of those provisions that yeah, it's going to require consultation and some further thought. And then the school staff negotiating body is going to be, school support staff negotiating body is going to be reintroduced. So you may remember that it was abolished in 2010. It's going to be reintroduced. It potentially is going to be making recommendations for pay awards in 2027, 2028. So not too long off. But yeah, they're going to have a certain remit. So it's going to cover remuneration, terms and conditions of employment, training and career progression. There is a definition of what school support staff mean. Effectively, it's anyone who isn't a school teacher. And the House of Lords have had issues with this as well. They've said, look, you need to make sure that we're not kind of stifling innovative or improved terms and conditions for school support staff by having this body. The House of Commons said, no, it's fine. We'll reject this because people can already give more favourable terms if they want to. But there is going to be consultation on what this is going to look like, but this is going to be reintroduced. It's also going to be reintroduced alongside a social care negotiating body as well. Again, which will have a specific remit. There is a consultation which is open at the moment, which closes in January. So it's worth looking at that with regards to fair pay agreements in adult social care. So that'd be quite interesting because I know it's already a sector that's stretched with regards to trying to recruit employees and the pay that they're paid. And then the final couple of slides. So the House of Lords have said that the right to be accompanied at a disciplinary hearing and a grievance hearing should be extended to a certified professional companion. Now, the House of Commons and the Labour government have said, no, we're not having that because they thought it would increase the cost, complexity and length of those hearings, which I think it might do if you've got this certified companion. But what they have said to appease the House of Lords was that actually we are going to review what the right to be accompanied looks like. So watch this space on that. And also in the manifesto, the Labour government said they were going to bring in the right to switch off. That this isn't in the Employment Rights Bill. So the right to switch off effectively was where individuals could say, I finish work at 5, so at 5:01 you cannot contact me. Don't try and call me. Don't ask me to stay late because I'm not going to do it. I've got the right to switch off. There's going to be a code of practice on this, and it's going to suggest ways that organisations can look at helping individuals switch off. But it's not going to be in the Employment Rights Bill. But I think another key takeaway is to think about this right to switch off, think about the code of practice. So think about if you've got people who are constantly working too much, if you've got WhatsApp groups that are used for work that are constantly pinging, think about putting measures in place to protect people's time so they've got time to rest and recuperate when they're not working. So yes, I think like I said, we've talked about key takeaways throughout, but just think about your policies, think about your procedures, think about your processes. We will keep you appraised of developments as and when they occur. There's going to be lots going on, and I think we're going to have another session in the new year, I think, Ruth, aren't we? To talk about the changes, what's happened, and if the bill receives royal assent. Hopefully it will at some point.
Absolutely, absolutely. And I think, it is going to be a case of watch this space. There is a lot of information, and we know it's going to apply differently to some of you out there. We've had some of the really good questions this morning. I'm sure there's plenty more for you to think about. I am conscious that we are very just over our time. So if anybody does have any quick questions, feel free to put them through. But if not, we would be happy to take questions offline as well. So if you do go away and think there's something you want to know about, feel free to get in contact with us. Kat and I's details are all over the internet. Will be sent to you after this event with the slides. So, if you do have something, do get in touch, but look out for our events, and hopefully we look forward to seeing you all again very soon. But my absolute thanks to Kat. She has worked tirelessly on this and will be helping you going forward and helping us as a team. So Thank you so much, Kat. I think that's been a really good session, and hopefully all of you have got some really good information. But we look forward to seeing you all again soon, and thank you for attending. Um, and if you've got any questions, as I say, do feel free to contact us offline
Of
as well.
course. Of course. Thanks, everyone.
Thanks.